Welcome to our 3PB brunch session. My name is Matiss Krumins. I'm one of the barristers at 3PB, and I deal mostly with care, public law matters. And Harriet is the other presenter with us today, and she is a private law practitioner who deals with children, private cases, domestic abuse cases, and financial remedy cases. We're going to be two different topics today. Harriet's going to go first, and she's going to be talking to you about Re-Why and the decision there by Sir Andrew McFarlane. And then after that, I'm going to be talking to you about the recent significant change to deprivation of liberty, and in particular how that affects children's cases.
Thank you, Matiss. So as you've heard, I'm going to be talking to you today about an overview of the decision Re-Why and particularly implications for practitioners. So firstly, I'm going to be addressing the facts of this case, some key points from the judgment, and then a reminder of some of the key points from the Family Justice Council guidance in 2024, which was approved by the President in that judgment. So firstly, looking at the facts of that case, this was an application by a mother to set aside findings of fact made in 2019. The application was first made in 2025, but the case was considering decisions that had been taken in 2019. So going back to the beginning of that case, in December 2014, two parents separated, and at that time they had two young children. In 2018, the father started proceedings seeking an order that the children live with him. Not unusually, both parents made allegations of abuse against the other. And the case was listed in October 2019 for a fact-finding hearing. But in advance of that fact-finding hearing, a report had been ordered from Melanie Gill. She was described as a single joint expert psychologist and who'd been asked to do a specialist family assessment. There are a number of other judgments that have been published about Melanie Gill's role in other cases. I'm not going to go into those today, but for the purposes of this, she had no clinical or therapeutic practice and is not a chartered psychologist. She suggested in her report that the children's behaviour was directly influenced by their mother's hostile antipathy towards the father to the point of hatred. She found that there was extensive evidence the children were actively being alienated and suggested the children were at continued risk if they were in their mother's care. The children's guardian aligned with that report and recommended the children move into the father's care. As a reminder, this was before any fact-finding hearing had been held. So that October 2019 hearing was listed as a fact-finding. The judge decided that he would only hear evidence from Miss Gill initially and not the other parties as anticipated. And that was on the basis of Miss Gill's evidence that if there were findings made of domestic abuse, it wouldn't change her recommendations, including if allegations were made on the mother's allegations of physical abuse, findings were made on the allegations of physical abuse and rape. The position the Mothers' Council took in that hearing was that the court needed to conduct a fact-finding to consider the mother's allegations of domestic abuse, determine that factual matrix, and then contextualise the mother's hatred for the father and consider the alienation issues as alleged. But the trial judge said that because the expert had said that even those findings being made wouldn't change her recommendations, he concluded he didn't need to hold the fact-finding hearing as it wouldn't change the recommendation and therefore wouldn't assist him in dealing with any of those issues. So by December 2019, the court then determined the children had been alienated from their father as a result of the mother's negative attitude. And in December, an order was made for the children to live with their father effectively immediately, then aged 12 and 9. The mother had lodged an appeal about the fact-finding, but it hadn't been determined by the time of that hearing. The final hearing was then held in May 2020, by which time the children had been in the father's care for 5 months and had had no contact with the mother. The mother was also a litigant in person by this point. A final order was made that the children lived with father and had no contact with their mother, effectively until further order, and that was particularly until she had done the specific therapy recommended by Ms. Gill. And as you can see from that final bullet point, the mother shall not be allowed any contact with the children until further order, and that was supported by additional orders. The mother applied to vary this order in 2021. She was unsuccessful. The court also then imposed a Section 9114 order to act as a bit of a filter, and her permission to appeal was refused. So the effect of all of this was that these children did not have any contact with their mother from the end of 2019 until 2025. In April 2025, the mother then made an application to set aside those previous findings of fact from 2019, relying on significant new evidence, particularly the case of Reece C. Before the President, and the guidance that the Family Justice Council had provided in December 2024. By 2025, the oldest child was now an adult. She wasn't engaged in these proceedings, but of her own volition, at some point in 2025, she had gone to live with her mother for some months, and she then returned to her father's care. By November of 2025, the younger child had left the father's care and had gone to find his mother. He found her, but because of the previous findings that had been made, he wasn't allowed to remain with her, and he was removed into police protection initially, then into foster care, and then moved to live with a family friend. But he was having increasing contact with his mother, and he was in fact separately represented within these proceedings. By the time the case came before the President in January of this year, he was regularly spending 8 hours with his mother. So the mother's application was for those findings to be set aside. And the President's decision was as follows. So firstly, he was damning in his views about the conduct of the 2019 proceedings. So I've highlighted paragraph 5 here. He was clear, every agency involved in these proceedings can be seen to have been at fault. And by every agency, he means CAFCAS, the children's solicitor, the local authority, and the court. You can't really get much clearer than that in terms of the condemnation. At paragraph 82, then, he also confirms and approves the submissions made by the Mother's Council at that October 2019 attempted fact-finding. So he's made very plainly clear here, if there was any doubt, that where a fact-finding hearing is necessary, that should take place before the expert's reports or perhaps a Section 7 report. He's determined that the court in 2019 was in error in directing final reports from the expert and from the guardian before that fact-finding process had taken place. And he said the decision to hear the expert first and no other witnesses at the fact-finding was a fundamental error. So his decision was to set those findings aside, and he ordered that the younger child would live with the mother. Some key points from this judgment then, firstly in relation to expert witnesses. Paragraph 73, which is on the screen, and 74, which I'll come to, is very clear in terms of how expert witnesses should be considered as suitable to provide a report. So he sets out here that it's good practice to ask the proposed expert if they hold a HCPC protected title, what it is, and then consider the issue of whether a registered or a chartered requirement. Paragraph 74, he emphasises here that the degree of rigour that we see in public law applications and public law proceedings should be mirrored in private law proceedings when assessing the qualifications of an expert. So key points for practitioners here are looking into the regulation of any proposed expert, whether they hold a protected title and what it is, and that consideration of whether the proposed expert is registered, are they chartered? If they're neither, can it be justified for any other reason in the circumstances of the case? Moving on then to the guidance he gives on alienating behaviour. The next few slides are all paragraph 75 of the judgment, but he sets out 7 steps to look at this modern approach, which is hopefully easy to follow. So step 1 is clear that there must be, the reason for the investigation must be a child's unexplained reluctance, resistance, or refusal to spend time with the parent. So it is not simply enough to allege that there are alienating behaviours. You have to be able to demonstrate that the child or children is demonstrating this triple R, reluctance, resistance, or refusal. I would normally expect that it's going to be relatively clear if they are or they are not. That definition is from the Family Justice Council guidance, which I'll return to. Point 2, this is where an element of fact-finding comes in. So where you have that reluctance, resistance, or refusal, then the court needs to consider, is that a consequence of the action of the estranged parent? So firstly, is it present? And secondly, it's for the court to determine if the allegations of abuse are found to be true, and therefore could this behaviour be a consequence? Point 3 then sets out that if there are no findings made to justify the reaction, and the court hasn't found that it's caused by the child's ordinary alignment, affinity, or attachment, only then does the court move on to considering if the other parent is engaged in alienating behaviour. So you'll see from these 3 points so far that quite a lot has to be established before the court turns to that. Again, that's emphasised in paragraph 4. It's only after you've gone through steps 1, 2, and 3 that the court then looks at the potential for alienating behaviours. Paragraph 5, again, sums this up quite nicely. The route here is that if there is, the court has to consider if there's a fact-finding process to be dealt with, and the focus of that is firstly to determine the issues of domestic abuse, and then, if findings are made or not made, to consider whether the child's reluctance or refusal is an appropriate, justified reaction to that abusive behaviour, or potentially the result of protective behaviour or a traumatic response from the victim parent. Further guidance here, paragraph 6, the court shouldn't be just looking at alienating behaviour on its own without determining the underlying facts and particularly primary issue of domestic abuse first. And then point 7, emphasising that it's not to appoint an expert unless and until there is clarity and, if necessary, facts found. I think the guidance hopefully is clear and helpful. This is something that as practitioners, you're likely to be dealing with frequently. A statistic I was able to find was that in 2023, 70% of family court cases in England and Wales featured allegations of parental alienation or alienating behaviours. So this is something you're likely to be very familiar with already, and you may well need to guide the court into the approach to be followed in determining these allegations and dealing with cases where they are raised. The President in this judgment has endorsed the contents of the Family Justice Council guidance in December 2024, and I've given you the long title of that guidance at the bullet points here. So again, I'm sure it's a document that many of you will be familiar with already, but I thought it would be helpful to have a refresher 18 months on in light of the endorsement that's been given in this judgment. So Family Justice Council position is that the suggestion that parental alienation is a syndrome is something that has no evidential basis, and that's considered to be a harmful pseudoscience. So rather than using that term alienation, the guidance is clear that first you address this reluctance, resistance, or refusal, and then consider if it's justified, and then if there is evidence of that alienating behaviour, rather than just the term alienation. Paragraph 10 of the guidance sets out the test that we've been looking at. These are the definition of the elements that are to be established before a finding of alienating behaviour could be made. So that first limb, again, the child is reluctant, resisting, or refusing. So firstly, in your cases, you'd want them to think, well, is it accepted this is happening? It's unlikely that if a child is spending time regularly with another parent, that's going to be found. So firstly, what's actually the circumstances, and does it meet this definition of reluctance, resisting, or refusal in the terms meant here? Then that second limb, again, is it a justified reaction or appropriate justified rejection by the child, or is it caused by any other factor, such as the child's alignment, affinity, or attachment? And then limb 3, finally, has the other parent engaged in behaviours that have directly or indirectly impacted on that child, leading to reluctance, resistance, or refusal? So the guidance makes clear at some length that there are many reasons that a child might withdraw from a relationship with a parent, and that can be for a variety of reasons. It may well be that they come to their own conclusions about what's happened in their family and how it impacts their attitude. It may be that they have that particular alignment or affinity with one parent, just prefer spending time with them. It may, in some cases, be an attachment strategy. And it highlights that the parent and child behaviour may, in fact, be a traumatic response to abuse. This guidance makes clear also that domestic abuse allegations and the allegations of alienating behaviour cannot be equated, and the risk, relevance, and weight of one allegation versus another shouldn't be considered to be equal. The guidance approves the definition given by the President in his previous judgment in Re C from 2023, again, that we're not trying to diagnose a syndrome of parental alienation, but the focus needs to be looking at the behaviours and the court focusing on whether those particular behaviours have been found to take place within the individual family that's before the court, and the impact that may have had on the relationship that a child has with their parent. So looking to some of the more practical considerations within this guidance, case management and allocation is something that's dealt with in this guidance, again, at some length. So it's emphasised that early on in cases, you need to consider the nature, seriousness, and complexity of the issues raised, and the court will need to determine the allocation appropriately. It's made clear that if one of the 3 elements is absent, so that paragraph 10 definition of the resistance, whether it's justified, and then whether there's evidence of alienating behaviours, if one or more of those 3 elements are absent, then the case may remain with magistrates unless there are other matters that justify reallocation. It's also made clear that these allegations of alienating behaviour can be made at any time within proceedings, and the court shouldn't be afraid to case manage matters robustly and reallocate if necessary. Certainly, in my experience, reallocation is something that courts can be reluctant to reconsider midway through proceedings, which is often entirely understandable, but it's a helpful reminder for practitioners that this is something to be kept under review. And if a case has developed and changed since the initial allocation, then that is something to keep an eye on. It's also made clear that certainly if these are allegations that are raised at the first hearing, it's not just enough for parties to assert that they are concerned about the prospect of alienating behaviour, but it's incumbent on the parties to help the court understand their case. So if your client is the one raising these concerns, then they must be able to spell out why at the earliest opportunity, likely with reference to these definitions and guidance. The factual matrix, then, that guidance makes clear it's for the court to consider if fact-finding is relevant and needs to be done in a particular case, whether it's proportionate and necessary. And it's the role of the court to determine the factual matrix. It's not for experts to diagnose this. The court should begin with considering domestic abuse allegations if they are present, and then review alienating behaviour allegations through that prism. And if the court finds that domestic abuse has occurred, resulting in that justified resistance, then the allegations of alienating behaviour will fail. It is emphasised that all 3 elements need to be made out, and in particular that findings are likely to be rare. It's also said that false allegations of domestic abuse will not necessarily constitute alienating behaviour unless there is evidence that a child has been manipulated into an unjustified reluctance. And finally, on that point, where findings have been made, it's one part of a factual matrix. It's not an automatic trigger for a change of residence, and that is very much emphasised. if your case is one where a transfer of residence is something that's being contemplated, paragraph 95 is quite helpful, where it makes clear that a guardian may invite the court to direct a Section 37 report. And it is made clear that the guardian is unlikely to be in a position to assist with the mechanics of a move if that is something the court is contemplating. But that is something that the local authority is better placed to report on, which may be of relevance to some of the cases that we deal with. So I hope that has been helpful. Thank you for your time this morning. If you have any questions, please put them in the chat and then we will answer them at the end. But now I'm going to turn over to Matiss, who is a public law specialist and a care practitioner, and he will be addressing you next. Thank you.
So hopefully you can all see my presentation, and as Harriet said, if you've got any questions, we'll do our best to answer them at the end. You'll find in Zoom there's a Q&A box. If you can put them there, that's great. If you put them in the chat, we'll do our best to answer questions at the end. I'm going to talk to you about deprivation of liberty and the recent Supreme Court case in respect of it. I've given this presentation now, a training as 4 hours and an hour, so I'm going to try and do it in half an hour and see how far we can get with it. It's not straightforward in respect of it, because it's been a quite significant shift change in respect of what's happened. And so the case that the Supreme Court decided has the very accessible title of a reference by the Attorney General for Northern Ireland of a devolution issue under paragraph 24 of Schedule 10 to the Northern Ireland Act 1998. I simply call it AGNI, and it is a full 7-panel of the Lord Justices, and it's a unanimous decision given by the Supreme Court, with judgment having been given earlier this month. The case itself is of little assistance because there's no underlying facts in the case. It was a question raised by the Attorney General of Northern Ireland as to the implementation of the Mental Capacity Act in Northern Ireland and changes that were going to be made in respect of Article 5. And so it was a theoretical question as to the impact, and the Supreme Court went and decided to extend the question and answer and relook at the issue of deprivation of liberty generally. And there were a number of policy reasons they gave for that, and that's effectively the enormous increase in the applications for deprivation of liberty. The primary focus of the case was adults, but it did involve some consideration of the children law, but it has a substantive impact on matters that we have in relation to children and deprivation of liberty cases there. So the first thing to know from AGNI is that the Supreme Court overturned the previous Supreme Court of decision of Cheshire West. In part, we'll have to understand what Cheshire West did and how they've changed it, so you can see how the procedure, the tests that have been applied, have changed substantively. Now, what the Supreme Court did was they reaffirmed, and this is going to be fundamental to your understanding of deprivation of liberty, is understanding what Stork and Germany had said. That is the starting point. What are your 3 elements of deprivation? You need an objective element, a subjective element, and attribution. Otherwise, we often call it imputability to the state. I'm not going to cover the issue of imputability. That hasn't changed with this decision. What this decision looked at was the objective and subjective elements. Effectively, it reiterated that deprivation is what they repeatedly call a paradigm case. The paradigm case is detention in a cell. It can also mean detention in a psychiatric hospital and social care situations. And so what you're now doing is looking back and making sure you're comparing back to the paradigm case as to how close you are to that. Effectively, what a deprivation of liberty is, and the case reiterates this, is that your liberty is one of physical liberty. It's your ability to physically be free to act, and the state ought not to deprive you of your liberty, say, for example, in terms of criminal punishment or for other good reasons. And if you are deprived of your liberty, say Article 5 requires that there is a speedy court decision made in respect of that, and you're provided assistance. And in cases where, and we often deal with these cases, where you have a lengthy period or an indeterminate period, you're entitled to reasonable reviews of your deprivation of liberty. The issues have all arisen in respect to the lack of capacity. And you have to remember, when you have a lack of capacity for Article 5, you need to have special safeguards in order to protect people's Article 5 rights. So that's part of the Supreme Court's starting point. It recognised that effectively, those of you who may not practice in adults, there is a substantive DoL scheme which involves professional assessment, independent questions of capacity, best interest decisions. And that DoL scheme exploded in its use following the decision of Cheshire West. That's because effectively what Cheshire West said was capacity was not relevant. Consent was not relevant. Capacity, if someone lacked capacity, they couldn't consent. And reiterated the point, a gilded cage is still a cage. That became known as the Cheshire West acid test. It was established that if you lacked capacity, you couldn't give valid consent. And so you couldn't have what is known as the subjective element, which is the issue of consent, and therefore you'd have a DoL. What happened as a result of that decision, I think the statistics were, in brief, that prior to Cheshire West, in adults, there are some 14,000 cases a year. After Cheshire West, immediately after Cheshire West, there was 140 odd thousand cases. And by, I think, last year or the year before, there were estimated to be 300,000 cases, just adults relating to deprivation of liberty. Those are cases within the DoL scheme and outside of the DoL scheme. And so you can see there's an enormous growth of cases, which resulted in fact, many of the time requirements not being met in the cases because the system couldn't cope. And so the Supreme Court went back to looking at the question is, can a person give consent through their expression of their current wishes and feelings where they lack capacity? That goes beyond mere acquiescence regarding their confinement. And their answer now is yes. And if it's yes, then you don't need to do all the authorization procedures. But of course, they remind us that the other safeguards apply. So that's Article 2 protections, Article 3 protections, Article 8 protections. Briefly, it is an unusual decision of the Supreme Court because it's overturned a previous decision of the Supreme Court. Cheshire West was binding. They had to rely upon what was the House of Lords 1966 practice statement to overturn it. And effectively, they said there was no relevant change in European law since Cheshire West. And their argument was that Cheshire West was significantly divergent from European case law in Article 5, that it justified an entire review of Article 5. And so the net result of that review was the Supreme Court found the previous Supreme Court decision was wrong and overturned it. Now I'm going to give you, I think it's 5 slides of what the answer to the question the Supreme Court did, and we'll go back through those in a bit more detail. I'm not normally in presentations want to read things out from the screen, but I think these are important points out of the decision so you can see what the Supreme Court is saying. And what they said was the starting point in assessing whether someone has been deprived of liberty within the meaning of Article 5 is the specific situation of the individual concerned. And the assessment is multifactorial. That's an issue we'll come back to quite a lot. With account taken of a whole range of factors, including the type, duration, effects, and manner of implementation of the measure in question, the judgments of the European Court show that no single fact is determinative. In addition to the objective element of confinement in a restricted space for a significant period, an individual will only be considered to be deprived of their liberty if, as an additional subjective element, they have not validly consented to the confinement in question. So this is a reiteration point. So you need to still have the both elements. It needs to objectively be a confinement that amounts to a deprivation of liberty. And secondly, you need a subjective element where the person has not consented to that deprivation. Those both are complex ideas, because whereas before in Cheshire West, it was clear if the person lacked capacity, they couldn't consent, therefore you were looking towards deprivation. Objective elements under the acid tests were very clear. You have a comparator to a non-disabled individual and a look at very simple things as to control. And so often cases would come to me in respect of children, and you could establish deprivation quite simply if, for example, the doors to a property were locked, the windows are locked, someone will be prevented from going out. That is no longer accurate. That is no longer the position we're in. Valid consent is therefore a powerful factor in the assessment. It is an autonomous concept and not equated with concepts of consent for the purposes of waiver of rights under the Convention or of legal capacity in domestic law. The fact that an individual lacks legal capacity to decide on their living and care arrangements does not necessarily mean that they are de facto unable to understand and consent to those arrangements in a manner that prevents those arrangements from becoming a deprivation of liberty. This is a fundamental part of the decision, which is that you now need to forget the fact that whether someone has or has not got legal capacity pursuant to the Mental Capacity Act. What you're now looking at is an entirely different test that's only applied for the purposes of Article 5. And that test is, do they consent to it, either by way of verbal consent to it, or is there some form of opposition to it that you can infer that they don't consent to their arrangements? It is a much lower test than that before, and it's something to bear in mind. So remember, legal capacity is not relevant. As part of the training, I'm not going to consider the first point, which is about the waiver of rights under the Convention. In order to waive your rights, I'll simply say this, is that there's a very high test for someone to be put in a position where they have sufficient information and capacity to waive their rights under the Convention. It rarely arises, and it's rarely a situation where the European courts have accepted someone has actually waived their rights under the Convention. It could arise, but it's much rarer. The main issue is that of legal capacity, and the fact that legal capacity is no longer the test for considering whether someone consents or not to a deprivation. They go on to say, on the contrary, an individual without legal capacity under domestic law, but who's conscious of their environment and has a basic understanding of their living circumstances so that they can express their view about the situation, who manifests their acceptance of the situation they are in, should have their opinion respected when an assessment is made of whether they are deprived of liberty under Article 5. The Supreme Court reminded us that it is important to remember individuals with significant limitations and disabilities are still entitled to significant respect to their individuality and their opinions. They may lack legal capacity, but they may well have a very good and clear opinion as to what their living circumstances are, whether they agree with them, whether they don't agree with them. And it goes on to say, although the objective and subjective elements of the deprivation of liberty are considered sequentially by the European Court in the assessment of the applicant's specific situation, there is an overlap. The requirement to take account of the type and effects and manner of implementation of the measure in question means that the assessment of the objective element can take account of the specific context and the circumstances of the restrictive measures that are different from the paradigm of confinement cell. So this is a reminder that although you have two separate elements that need to be considered as a part of the deprivation assessment, they overlap with one another. And one of the clearest situations of overlap is where you have a situation whereby someone is being administered medications that either are designed to restrict their behaviours. So it may be that someone is provided a sedative when they become dysregulated. Alternative, they could also have a tranquilizing effect upon that individual, or used to modify their emotional reactions. Those are all objective elements that need to be looked at, but they're also relevant to the subjective element of consent. They're relevant in respect of whether or not that individual's consent is adversely affected by the type of measure that's being taken. And so you have to bear in mind, effectively what we're being told to do is go back and do holistic assessments of these, to take consideration of all the circumstances, and in particular considering the objective and subjective elements, but don't silo them. There will be overlap, and you have to consider the overlaps and the impacts of those. Hopefully, I think this is the final slide on it. The approach of the European Court means that the effect of restrictions on an individual, including their compliance and the lack of objection, if they are capable of objecting or giving tacit agreement, is relevant in assessing the objective element of confinement. But the relative normality of the placement is also a relevant factor in this assessment. Similarly, in situations that are far from the paradigm of confinement in a cell, the purpose for which a measure has been taken is a factor to be considered. And so that is a reminder that effectively all of the principles of Cheshire West are going, and I will go through those in a second, so you can see what's significantly changed. And you're looking at issues as the normality of the placement. You're looking at as to how close are you to a confinement in a prison cell when considering the deprivation. Sorry, there was one more. That's my fault. The European Court has recognised that the process of assessing whether there has been a deprivation of liberty is no easy task in some contexts, and may give rise to difficulties, especially in borderline or marginal cases. Equally, it may sometimes be difficult to ascertain the true feelings or preferences of vulnerable individuals who do not have mental capacity to decide on their living arrangements. The approach should be practical and realistic. Where there is serious doubt, no inference of valid consent should be drawn. So this is a reminder and recognition by the Supreme Court that we've gone from a situation where Cheshire West made it relatively simple for practitioners, that's both social work and lawyers, to identify deprivation of liberty cases. Those cases are now much more complicated to identify. And then on the spectrum, there will be cases that are obvious deprivation of liberty, and there are cases that are obviously not. But there's going to be a whole spectrum of cases in the middle that are going to be, to some degree, quite difficult to determine whether or not there is a deprivation of liberty, and will turn on the individual facts of the case, where you may even have cases that are very similar with one another, and one will be a deprivation and one won't. So what the Supreme Court did was recognise the bright line test of Cheshire West is gone. There's going to be easier and harder cases, and the word that is repeatedly used is it's necessary to have a multifactorial approach, which and you need to, as part of that, weigh all the evidence carefully. So breaking it down into the different elements that need to be considered in any assessment. First, you're told to concentrate on the concrete situation. Other words are used as well, like specific situation. Effectively, what it means is take account of all the factors in the case. That includes the type, duration, effect, manner, and implementation of the measures in question. You're reminded no single factor is determinative. So as before, it could have been very simple, where you had a situation whereby a young person was, for example, escorted at all times outside of a property, would never be allowed to be alone. Those cases would often be deprivation of liberties under Cheshire West. That single factor is no longer as determinative, and will need to be weighed up against all the other factors within a case. there's a reminder that there's a difference between a deprivation of liberty and a restriction of liberty. So there'll be many cases where there is a restriction on someone's liberty. Just because there is a restriction doesn't mean there's a deprivation. And the second issue, when you're looking at that issue, is the question is one of degree and intensity, not a question of nature or substance. The best way I can explain that in the shorter training is you need to look at it. The same factors may point to a deprivation or not, but it depends on how they're used. In a very different example, there's the European cases on whether or not someone is deprived of their liberty when they are held in passport control. Perhaps somewhat topical in terms of summer holidays and everything, but we're all aware of the substantive queues going through border control checking procedures. And there have been cases to argue, well, if someone goes and travels to another country and then they are held at border control for multiple hours, are they deprived of their liberty? Well, the answer is, again, not one of nature and substance. You going through the border control is a restriction on your liberty. You're not free to leave. You will be arrested if you attempt to leave that area without going through the processes required by a particular country. But it's the question of degree and intensity. And the European Court said effectively a number of hours having to wait is not a deprivation of liberty. You've consented to that. You knew you had to go through border control when you intended to travel to another country. And secondly, the intensity of it is not such to amount to a deprivation of liberty. But there's another case where it was a deprivation of liberty to the individual hold for a very substantive period of time whilst processing through border control. And that's your example of it's not the nature of substance. Both cases revolve around the nature and so both have the same nature and substance, which is they're held at border control in very similar circumstances. It's the degree and intensity of those restrictions that change it from a restriction to a deprivation. Second point, it's the person's view is very important. There needs to be an absence of valid consent. The effect of the restrictions need to be considered. So, for example, tranquilizing medication. If an individual objects, there's more likely to be conflict in the placement. For example, you'll have physical restraints, their objections are overruled, the necessary elements of coercion may be present because that person's being forced to live where they don't want to. You may be able to infer the absence of objection because you don't have those levels of conflict, which is also a relevant consideration. That may indicate an individual who's otherwise not able to communicate is in fact communicating their wishes and feelings by the lack of conflict. The Supreme Court's point was, if someone is very happy with their circumstances, it is very unlikely to be a deprivation of liberty. And again, in borderline cases, you look at whether you look back to the paradigm of the prison cell. So the person's view, the person's actions, the person's behaviour is relevant in order to determine whether or not you have the subjective elements, bearing in mind the impact of any objective elements on that. You could have problems. They recognise you can have problems getting views from individuals who have profound cognitive disabilities. And again, there's going to be a spectrum of cases where eliciting positive expressions of wishes and feelings is impossible. And at the other end, where you can get tacit positive indication, this is going to be a question of assessment. As a reminder, though, compliance and acquiescence is not enough. But just because someone isn't able to verbally express their views, it's a matter of assessment as to whether that individual accepts, consents, is content where they are. Third point, the question is one of physical liberty. This wasn't set out in the Cheshire West test. Physical liberty means just that. They say it is obvious that someone in a category A prison or high security psychiatric hospital is going to be deprived of their physical liberty. It is much harder to say that if someone is living independently as possible in their own accommodation or family home. The restrictions are likely to be very different. Normality is something that to be considered, again, something that Cheshire West told us not to consider. Normality of circumstances is a relevant factor. You're reminded by the Supreme Court there's no decision of the European Court when an individual living in their own home has been deemed to be deprived of their own liberty. This doesn't mean it can't occur, but it's less likely to occur, as the interventions will need to be more severe with restraint, medication, seclusion, all being considered. Fourthly, there's a need for coercion or external imposed restrictions on an individual that prevent them from exercising their fundamental right to physical liberty. And the person's own physical or mental condition is relevant to this. And the example they give is an individual who's in their final stages of dementia, confined to a bed, and they're so cognitively impaired, they're unable to even form the idea of swallowing, let alone moving about it. But no one's interfering, no one's forcing a deprivation of liberty. They're saying that is not a deprivation of liberty. The mere inability is not lack of freedom. So there needs to be an external restriction that's being imposed on an individual. But someone who's restricted by virtue of their physical disability is not restricted in terms of the liberty by other methods, is unlikely to be deprived of liberty. It's not entirely impossible. There are some complexities in those examples, but it also will have to do with how much accessibility they are to finding assistance. But you're reminded, do not compare to a non-disabled comparator. So we are that test is now gone, along with the rest of Cheshire West. Those are no longer the comparisons we make. We are told now the purpose of the confinement is relevant. Previously, it was the gilded cage is still a cage, but that is no longer the approach to be taken. Where a purpose is for the purposes of punishment, it is more likely to be a deprivation of liberty. So prison, for example, is a clear that purpose there is for a punishment of an individual, it's a deprivation of their liberty. Where the purpose is more benevolent, it is less likely to be a deprivation of liberty. And again, there's going to be a whole host of spectrum cases we have to validate. Again, the purpose of confinement alone won't determine it. It has to be considered as part of all the elements of a case. We've already covered the sixth point, just a reminder, legal capacity is not the same as a lack of valid consent. It's what is the de facto understanding of the individual. Cheshire West dealt with three cases, which are useful to look back on as to how they were determined and the impact as how they're determined now. And so the first two cases were sisters who were children at the very start, but were adults by the time. One of them was adult by the time in COP, and certainly adults by the time of the appeals. That was Mig and Meg. So they had different circumstances, and they assist certainly those of us working in children's cases to understand interpretations of this. And so Mig was the older sister. She had moderate to severe learning disabilities. She's very cognitive limited and has problems with her sight, communication, hearing. She has a very limited awareness of danger. For example, she needs help crossing a road. She lived in a foster placement in a private home with a foster mum who she referred to as Mummy. She was provided intensive support by the foster mother in almost every aspect of her life. She didn't receive any medication. There was no restraint. She wasn't locked in. She made no attempts to leave by herself, no wish to do so. But if she had done, the foster mother would have restrained her. Meg went to a further education college, daily trips, holidays with a foster mum. Very briefly, just a bit short in time, Mig was decided not to be deprived of her liberty by the Court of Protection by Parker. That was agreed with by the Court of Appeal, and then the Supreme Court, was the Cheshire West case, said that she was deprived of her liberty, and she was deprived of her liberty effectively by the act of the fact that she would have been restrained if the matter had arisen, and she'd been stopped from leaving the property. So effectively, she wasn't free to leave because the foster mother would have stopped her. Supreme Court now says Cheshire West was wrong, that Mig is not a deprivation of liberty, and that Parker J was correct at first instance. The indications were that she was happy, and that amounted to valid consent. The living conditions were as close as normal as possible, with a minimal element of confinement, and any confinement would have been for her benefit and protection. The objective element's not present. The court said that's very far removed from the prison cell. So cases like Mig's are not deprivations of liberty. Meg are different. Meg was living in an NHS residential home. She had learning disabilities, and her cognitive ability was limited, and she had occasional outbursts of challenging behaviour towards the other residents and sometimes required physical restraint. She was administered tranquilizing medication to control her anxiety. She would be locked in, had one-to-one, sometimes two-to-one support. She was under continuous supervision and control, which was exercised upon her. She was accompanied by staff whenever she left the home. She attended the same education college as her sister and had a full social life. She had no wish to go out on her own, but if she tried to leave, she would have been restrained. In terms of the background of that case, Baker J, who's now Lord Justice Baker, said that Meg was deprived of her liberty at first instance, and then the Court of Appeal overturned that and said she wasn't deprived of her liberty, and the Supreme Court overturned that as part of Cheshire West and said that she was deprived of her liberty by actions of the restrictions that were in place, and she was unable to consent to them. As you can see, there are more elements that would indicate a deprivation of liberty in terms of the objective element, but the Supreme Court decided that Meg would not have been a deprivation of liberty. She was happy living in the NHS facility. That amounted to valid consent. She did not wish to go out on her own. Tranquilizing medication was not administered for the view of disabling her from forming a view on her living circumstances, and this didn't appear to have this effect. Her response to her environment was that she was generally happy, even if she had occasional outbursts. They said there was no objective element of deprivation. The living arrangements were as normal as possible. The purpose of supervision was to meet her care needs rather than making her a prisoner. The physical restraint was for her protection and for others. It was not a punishment. The Supreme Court says this is far removed from the prison cell. And so again, we have a clear indication these cases do not amount to deprivations of liberty. That doesn't mean every case isn't going to, and what I've hopefully got across is we've gone from a situation where there is a very straightforward test to determine what is not a deprivation to a much more complicated scenario, one that requires a full assessment by social work professionals, considering all the factors in the case and balancing those out. I am going to suggest, however, a clear push from the Supreme Court as to the policy reasons for this decision and the changes they've made is that there'll be far fewer deprivations of liberty applications within the courts, and they're going to be scrutinised. We don't have substantive guidance in respect of children yet, and there are a large number of issues that will arise. I anticipate there'll be more guidance cases coming out from the lower courts in the interpretation of this. But that has been what I'm going to suggest is a brief overview of this, and I'm very happy to provide any organisation more substantive training in respect of this issue, as well as review any cases, because there are no easy answers and there's a lot more to cover in terms of all of these aspects have come. So just bear in mind, this is a very brief overview of it. But thank you very much for everyone for joining in.